Welcome to the deep dive. Today we're tackling, well, one of those really slippery ideas in contract law, the implied covenant of good faith and fair dealing. Sounds straightforward enough, right? Every deal, every single one, supposedly has this unwritten promise to act honorably. But here's the real puzzle we're digging into today. What happens when someone spots a loophole? When they cleverly restructure a deal or maybe lean hard on the precise narrow words of the contract just so they don't have to pay someone else what seems like a fair commission. When does smart, maybe even sharp business practice cross over into actual legal bad faith? We're going to dissect a case called Johnston v. Palmer. It's a Mississippi Court of Appeals decision involving a brokerage deal that went sideways thanks to a defendant who was, let's say, quite strategic. Now, for you listening, this deep dive should give you a really clear step-by-step way to analyze this issue, this breach of good faith, which often feels pretty fuzzy in real life. So what's our game plan? How do we actually get to grips with how the court tackles such a tricky claim?
Okay, yeah, we need a solid plan. First, we absolutely have to state the black letter rule. What is this implied covenant? And crucially, how do courts define bad faith? Because, spoiler alert, it's a tougher definition than you might think. Then, we'll take those definitions and apply them directly to the facts in Johnston v. Palmer. They're fascinating facts, actually. We'll use that structured fire act method to really see why the broker didn't get his commission in the end. And finally, we'll pull it all together into like an actionable checklist, something you can use to spot and analyze a good faith issue yourself.
All right, let's do it. Starting at square one. What's the basic legal rule here about this implied covenant? Does it always exist?
Yes, absolutely. It's universal. The rule, coming from cases like San v. Murray is really clear. All contracts, no exceptions, have this built-in covenant of good faith and fair dealing. It just exists automatically.
Okay, so it's always there, but what about breaching it? What actually counts as bad faith?
Right. That's where it gets interesting. The breach itself is defined as bad faith. And that's generally described as, quote, some conduct which violates standards of decency, fairness, or reasonableness.
Decency, fairness, or reasonableness. That sounds kind of vague, doesn't it? Like almost anything could fit.
It does sound soft, yeah. And that's why courts, like in Bailey v. Bailey, added a critical layer. They clarified the intent required. Bad faith isn't just making a mistake or being negligent or even bad judgment. Instead, it implies, and this is the key phrase, the conscious doing of a wrong because of dishonest purpose or moral obliquity.
Wow. Moral obliquity. That's quite something. It sounds less like a contract breach and more like, well, near fraud.
Exactly. It sets a really high bar. You're not just looking for an outcome that seems unfair. You need evidence of, like a deliberate, dishonest, almost malicious intention. Makes it tough for the person claiming breach.
No kidding. Okay, so that's the high bar for intent. What about the action itself? Is this covenant just about not doing bad things, or do you actually have to, help things along? Is there a duty to cooperate?
That's the second key rule. And yes, there is an affirmative duty. It's not just passive. Referencing Sinek again, a party has a duty not only to refrain from hindering or preventing the other party's performance or the conditions of their own duty, but also, and this is important, to take some affirmative steps to cooperate in achieving these goals. So you can't just sit back and watch things fail. If you can help reasonably, you've got to, cooperate, or at least not actively block progress.
Okay, so we have two big rules. Cooperate actively and don't act with moral obliquity. Let's see how these played out in a real case. Let's analyze Johnston v. Palmer. First, what are the legally dispositive facts?
Right. So Gregory Johnston, he was a lawyer, but acting as a broker here. He introduced John Palmer and his company, Gulf South Capital, let's call it the clients, to a business opportunity with a company called USLF. Johnston himself drafted the brokerage agreement, and this is crucial. It gave him a 3% commission, calculated on the total money paid by the client specifically to any and all shareholders of USLF when the deal closed. Very narrow wording, drafted solely by Johnston. Okay, so after the introduction, Palmer basically tells Johnston, thanks, but we don't need you anymore. He starts negotiating directly with the USLF owners. And communication with Johnston, it just stops cold after September 2004. He's cut out. Then fast forward to February 2005, Palmer invests $1 million, but here's the twist. He doesn't buy stock from the USLF shareholders directly. No. He invests in a brand new company, USL, which was set up as a holding company to own the USLF assets. Palmer gets stock and options in this new USL. So when Johnston asks for his commission, Palmer says no. Why?
Because technically, literally, no money was paid directly to the original USLF shareholders, which is exactly what the narrow agreement Johnston wrote required.
Okay, that's a clever move. So what was the core legal issue the court had to decide?
The big question was, Did Palmer and Gulf South breach that implied covenant of good faith and fair dealing? Specifically, did they breach it by setting up this whole holding company structure, ISL, instead of buying directly from the USLF shareholders, essentially designing the deal to avoid paying Johnston's commission?
Right. So how did the court handle that? What rule did they apply to balance Palmer's duty to cooperate against his freedom to structure the deal how he wanted?
Well, they applied the rule we just talked about, the duty to cooperate affirmatively. But they added a really important limiter. They noted that the duty of good faith doesn't force a party to structure a deal in a specific way just to make sure the other guy gets paid. You still have freedom to arrange your business affairs, basically.
Okay, this is the heart of it then. Palmer definitely cut Johnston out, which seems like a failure to cooperate. So why wasn't that enough? Why didn't that prove bad faith? What was the court's analysis that let Palmer, well, get away with it?
This is exactly where the case turns. The court definitely saw that Palmer kept Johnston out of the loop. And they acknowledged that looks bad, potentially violating that cooperation duty. However, and this is the big however, Palmer's entire defense rested on the fact that he was following the strict, literal words of the agreement. And who wrote those words? Johnston did. Solely Johnston. The court put huge emphasis on that. The policy idea is if you're the one drafting the contract, especially if you're a lawyer like Johnston, and you make it narrow, you bear the risk that the other side might find a way to comply with the letter, if not the spirit. And critically, Johnston couldn't produce any real evidence, just suspicion, that creating the holding company, USL, was done for the full purpose of dodging the commission. Without proof of that dishonest purpose or moral obliquity, the high bar for bad faith just wasn't met.
Ah, okay. So it wasn't just that he restructured, it was that Johnston couldn't prove the only reason. The sole motivation for that restructuring was basically malice towards him. That's the key distinction, isn't it?
Precisely. The law protects your right to restructure for potentially legitimate reasons. Maybe tax advantages, maybe liability protection, maybe long-term investment strategy. As long as avoiding the payment isn't the only reason, the court isn't likely to call it bad faith, even if avoiding the payment is a nice side effect for that party.
And the conclusion from the court?
The conclusion was that there was no genuine issue of material facts showing Palmer or Gulf South breached the duty of good faith and fair dealing, strictly according to the terms Johnston himself had drafted. So, Palmer wins. Johnston gets nothing.
Right. That difference between being excluded, which feels unfair, and proving actual dishonest intent, which is legally required for bad faith, that's a tough line. Let's try a hypothetical to really cement this sole purpose idea for everyone listening. Make it stick. Okay, imagine you have a home seller. They sign a deal with a broker, and the deal says the broker gets paid only if the house sells to a, let's say, a natural person, like an individual human being. The seller finds an interested buyer. Everything looks set. But then, like the day before closing, the seller secretly forms a shell corporation, Seller Shell Co., sells the house to that company for the full price, and then immediately sells the shares of Seller Shell Co. to the original buyer. Then the seller tells the broker, sorry, no commission. The house was sold to a corporate entity, not a natural person, just like the contract allows. Now, in that situation where the company seems created purely at the last second, obviously just to avoid the commission, does that meet the conscious doing of a wrong or dishonest purpose standard from Bailey?
Oh, yeah. That scenario. That almost certainly is bad faith. It hits the mark. The key difference you see compared to Johnston is that sole purpose test becoming really obvious. In Johnston, Palmer had time, the deal structure was more complex, and he could plausibly argue there are other reasons for the holding company. It wasn't definitively proven otherwise. But in your hypothetical, creating a shell company literally hours before closing, with no other apparent business reason except to fit the loophole in the commission clause, that screams conscious doing of a wrong. That demonstrates the moral obliquity the courts talk about, the timing, the lack of any other justification. It points directly to the sole purpose being avoidance. That's likely bad faith.
That really clarifies it. Restructuring itself isn't the problem, it's why you did it. If the only reason was to stiff the other guy, that's bad faith. Otherwise, maybe not.
Exactly right. And understanding that difference is crucial when you're looking at these kinds of disputes.
Okay, great. We've seen the rules, seen them applied. For you listening, let's try to boil this down. What's the step-by-step diagnostic checklist we can build from all this? How can you analyze a potential good faith breach?
Okay, let's synthesize this into a practical checklist. 4 steps. Step 1, existence check. Super simple. Just remember, the covenant of good faith and fair dealing is inherent in all contracts. It's always there. You don't need to find it written down. Step 2, affirmative duty check. Ask, did the party you suspect of bad faith actually cooperate? Did they take reasonable steps to help the contract succeed? Or did they actively hinder things, refuse to cooperate, or like Palmer, cut the other party out of the loop? Failing to cooperate might be a breach of that duty, even if it's not full-blown bad faith yet. Palmer probably failed this step. Step 3, the malice motive check. This is the big one, the high hurdle. If their actions led to avoiding an obligation, was it just, bad judgment, or was it that conscious doing of a wrong because of dishonest purpose or moral obliquity? You need evidence pointing towards that near fraudulent intent. Step 4, the structure drafting risk check. Now zoom in on how this situation played out. Was non-payment the result of a specific restructuring? If yes, can the complaining party prove that the sole reason for that new structure was dodging the payment? And critically, remember the Johnston lesson. If the person complaining drafted the narrow terms themselves, the court's going to be much less sympathetic if the other party follows those terms literally. That's the drafter's risk.
That's a really clear framework. So putting it all together, what's the big takeaway for you? Well, it means that yes, there's a duty to be decent and cooperate in contracts, but crucially, that duty doesn't mean you have to ignore the actual words on the page, especially if the other side wrote them narrowly. You can often structure things to your advantage using the literal terms, provided you didn't do it with that specific, provable, dishonest intent, that moral obliquity. If you draft narrowly, you live with the consequences. Which brings us to a final thought. We saw Palmer cut Johnston out and restructure, supposedly for efficiency. Here's something for you to think about. What if Palmer, after being introduced by Johnston, had just walked away? Let the deal sit for, say, 6 months. Then, after Johnston's brokerage agreement had actually expired by its own terms, Palmer goes back to Adams and Edens and does the exact same deal they originally discussed. Would that scenario make a claim of bad faith stronger or weaker? Think about it. Is deliberately waiting out a contract term different from actively restructuring within the term to avoid payment? Where does dishonest purpose fit there? Something to chew on. Thanks for joining us for this deep dive.